streaming because, thank you very much. So I can see my second question has been answered. Thank you very much.
Okay.
Okay, so is that in the affirmative to both questions, Mr. Guillo?
It's in the affirmative that we're recording on Zoom and that we are live streaming. I'm not sure if anyone's in the courtroom using CourtSmart to record the proceeding.
I see. Do you have any direct communication with Ms. Butterfield?
I can excuse myself and come back.
Would you be so kind? And then I'll just hear from Mr. Pettingill as you do that.
Yes.
Thank you. Mr. Pettingill, I don't have it confirmed that the CourtSmart is running, but the Zoom session is recording and we do have the live stream. So anything you say can be retrieved. Does that present any cause for concern?
No,
Okay.
I accept it.
All right, thank you. Ms. King-Dean, any issue?
None, my lady, I'm fine.
Thank you. Yes. Mr. Pettingill.
Yes, my lady, thank you. I think that the key element to start with is the point your ladyship raised about, things being tainted. And I think once the court is able to look at it and consider that there is a tainting in some fashion, there is cause for considerable concern. My friend has made some meat with respect of the fact that, we could have joined these matters and therefore it's okay because perhaps we should have. But my lady, with respect to say we should have joined them or sorry, we should have joined them, to simply not put Humpty Dumpty back together again in the circumstances. And I will say this, reason why. Had it been that the Crown had, as they said they should have, decided to join the matters, my respectful view and observation is there would have been an application to sever. And that would be part of the process that the appellant was entitled to. That didn't happen. Let's say and this is all hypotheticals, this is where it's dangerous. Let's say for argument's sake that the learned judge rejected my application on severance, which I say invariably would have been made, and decided to join the trials, to join the counts and that they would be tried together. This is what invariably would have happened. The defense would strategize around the joinder. The defense would analyze what the Crown's case was with the joint charges and may or may not have presented particular evidence in a certain manner. That is invariably part of what has to transpire in a trial that is joined. What it should be of great concern to the court here is the Crown can't eat its cake and have it in relation to that issue. You can't say, well, we didn't join, but they were the type of trials that would have been joined in any event because it would have required a different analysis and a different approach. I.e., you might not have called Dr. Source. You may have approached the defense evidence in relation to the charges in a different manner. And the learned judge would have only seen the defendant once, therefore not conflating the issue of assessing her credibility on this case and then assessing her credibility on this case and deciding that, in his view, that she wasn't a credible witness and she wasn't a liar. Really having two opportunities and two bites at it to assess the witness, the one flowing into the other. So it is not okay. And I would say for the informed observer who knows this is how things should be going on, that you can do it this way, to endeavor to excuse by saying we should have done it a different way. And this court, with respect, in my deeply respectful submission, cannot and should not be drawn into the trap of giving a license to trials to be conducted in this manner. You either do or you don't. But if you don't, I decide to join, then it has to flow a certain way, and you are left with whatever tainting or poison occurs. You can't
Mr.
excuse
Pettingill,
that.
can I just remind you that the opportunity that you have at this stage is to reply on points of law that are raised.
Yeah.
I don't want for you to treat this as a general.
I apologize. No, I'll be very brief. Let me just say this. I was the point of law, and I should have started by saying this, is the issue, as my learned friend raised it, of joinder and severance, and what the legal approach is to dealing with that type of application, and how it necessarily impacts on the progress of a trial, and how that is a constitutional basis for fairness because of the way you would approach a different matrix with regard to the trial. If I could just commend to your ladyship at page 35, paragraph 35 of the Williams Court of Appeal judgment.
Mhm.
And in the final part there, his lordship concludes in citing the case of Lord Bingham the dicta of Lord Bingham and Dyer, as your ladyship did. It's incumbent on our judicial system in Bermuda so to organize its response and to ensure that the reasonable time requirement is honored. In saying that, his lordship recognized the magistrates rely upon counsel to provide an accurate estimate of the time. He concludes, my lady, in there saying, but separate and apart from all that, the need to avoid a long hearing becoming fragmented by multiple sittings over months and years is paramount. Notice that, months and years, and this was certainly months, some degree of months after a retrial, and is the task of the magistrate to ensure that the reasonable time requirement is indeed honored in this jurisdiction. With respect, it wasn't in this case. It may well have been had they been joined, but it wasn't. And what has happened is a fragmented process, and that's as candidly as clear as a pikestaff. A fragmented process has occurred, and the Court of Appeal, and indeed your ladyship, has been very, very clear on the view that at all costs that type of process should be avoided. If it is not, and the trial is anyway tainted by it, then the Section 6.1 rights to a fair trial and to are respectfully infringed. My lady, unless I can address any specific points of law or questions you have, that is my submission.
No, thank you very much. I would only observe that your client was not present, and that's unsurprising to me, given that there was a change of Zoom details.
She did try, my lady, I can tell you that, because
Yeah.
she texted me in the middle saying, are you on? And I said, no, I wasn't. And I didn't, sorry, I apologize, I didn't realize she wasn't on here.
So
I'm
that's
not,
fine. I would just want to note that no issue arises.
I wouldn't take any issue with that. I mean, the only, perhaps I should say this, the point of completeness that my client indicated by way of instruction, and I guess a fair point to raise, that her position on the adjournment with regard to the doctor being heard was more in line with the fact that Mr. Attridge, who is obviously very, very busy, as did the Crown, had Supreme Court matters that had to be prioritized, and that it was the combination of that, not just the question of delaying because of waiting for her, the doctor to be heard. That was her position. That was the only instruction I had during the break.
Okay, thank you.
Thank you.
It seems to me that we can then adjourn the matter of Rebecca Wellington. I'm going to reserve judgment and provide a written decision, which is pretty standard in these kinds of matters. And you can, I think, reasonably expect to see that within the next 6 weeks. Otherwise, you'll hear from the registrar with an indication as to what's more realistic.
Oblige, your ladyship.
Thank you.
Thank you, ma'am.
Expect you, Ms. King Dean, will remain on for the next appeal. Let me just change my papers. Thank you, Mr. Pettingill.
Thank you.
All right, Mr. Quayler, can I ask for you to just formally call the matter of Jamel Simons?
Yes, my lady.
Thank you.
The Supreme Court sitting in its appellate jurisdiction for case number 15 of 2021, Jamel Simons against the Queen, Mr. Paul Wilson appearing on behalf of the appellant, and Ms. Karen King Dean appearing on behalf of the respondent. These proceedings are before my lady, Mrs. Justice Sabir Williams.
Thank you. Okay, we have Mr. Wilson. Mr. Wilson, maybe I should bring it to your attention because you're sitting in front of an open window. It's difficult to actually see your face. You may not think it necessary, but I'll just draw it to your attention. You are sitting, so there's a light that's blinding your.
Yeah, yes, my lady. I can go around to the other side of my desk. I was just sitting here because of comfort, really.
Okay. It's a matter for you. I don't mind, but I don't mind, but it may be part of your advocacy for me to see the fullness of your presentation and expression and so forth. It's up
Yes,
to you.
ma'am. I'll change.
Mhm. Yes, that's much better. Thank you, Mr. Wilson. Do we not have Mr. Simons?
No, Mr. Simons isn't with me presently. My paralegal spoke with him yesterday and told him that he was to be present at Commercial Court number 2 for this afternoon's hearing, because it was still my understanding that we had gotten leave from you on the last occasion to appear in person.
That might be so, but the last appearance was on the 15th of July. And here we are in October. I think we all have to be realistic about how things are changing
Yes,
rapidly month to month. And obviously that will be subject to issues related to COVID-19.
right.
And I would also acknowledge, I think it's certainly my understanding that a practice direction or some sort of a circular was sent out in the last week or so from the court confirming that hearings will not be in person until further notice.
Right, I can appreciate that. I may have missed that circular. So I did, when the Zoom details were sent out by Ms. Butterfield, I did ask whether or not the in-person appearance had been changed.
I can
And
tell you,
after-
under these circumstances, I would want some indication from him if he would want you to proceed, but I'm not keen to proceed without knowing that he appreciates that we are appearing remotely and he's not here to witness the arguing of his appeal.
Right. Well, at this point, I'm not sure how to get in contact with him immediately. He
Right.
does have, he does have a home telephone, which is what we normally contact him on. We normally, if we can't speak to him directly, we leave messages for him to call us back.
Is he
Before I
someone that
left
would have
school-
difficulty appearing via Zoom?
He wouldn't be, I wouldn't expect that he would be able to appear via Zoom other than being present with me in my office, and I can accommodate, but
Not for this afternoon, obviously.
well, I don't know where he is, and I can't contact him immediately because he doesn't have a cell phone.
I see.
We only contact him via his home phone. I did leave instructions with Ms. Butterfield, such that if and when he shows up.
One moment, I have Ms. Butterfield very keenly trying to get my attention. Hold on.
Okay.
Mr. Wilson,
Yes, my lady.
I'm told that your client is here in Court 1.
Right.
And where's your office located?
We're directly across from Hamilton Pharmacy, which is just down the street, so it's less than 3 minutes walk.
Any other directions that we should give to him? How about
Yes.
this? Let me, can Mr. Wilson communicate with you directly by phone? Like, do you have a phone or
Yeah, I
something?
just texted him.
Okay, good. Can you just have a text exchange with Miss Butterfield
Yes, ma'am.
so that she can convey some direction to your client?
Okay.
How to get to your office, hopefully in the next 10, 15 minutes?
Yes, ma'am. I'll do that right now. I did
Okay.
actually mean to add her to
Good.
WhatsApp to send her
Yeah,
pictures. So I'll do that now, my lady.
okay. And I will stand the matter down until I think realistically, it looks like we shouldn't come back until 3:25. It's not 3:07. That should give them time to get settled and up with Mr. Wilson, yes?
Okay.
All right, yes?
I'm grateful. Thank you.
Okay, thank you. So we'll come back at 3:25.
Yes, ma'am.
Mr. Coelho, do you want me to go into a breakout room or? should I
Yes,
just-
my lady. And Ms. Kingdean, if you can just deactivate your camera.
All right, Mr. Wilson, you have your client with you?
Is there?
Yes, no, you didn't have to adjust your camera. I see him. That's him behind you, though, I presume. I just want you to confirm.
Ma'am. Yes, ma'am. That's Mr. Simons.
Okay, thank you. And can I just be reminded, Mr. Quillo, that the Court Smart is now up and running?
I will defer that inquiry to Ms. Butterfield, who I assume is in court.
I've just given her a message in relation to another matter. She may be away from her desk. Is there any issue in any event why we can't start? Because we are live streaming, so it seems to me that being able to access footage of the hearing will not be an issue. Mr. Wilson, Ms. King Dean,
No,
what's an invitation for your views?
no issue from us, my lady. We can
No
start.
issues, my lady.
Great, let's start. Thank you.
All right, my lady. So we filed the bundle and the amended skeleton. Can I just check to confirm that both the court and Ms. King received it?
I have an amended skeleton and I have two colorful binders. One is bundle A and the other is bundle B.
Yes, ma'am. Bundle A has the authorities on which the appellant relies, and
Yes,
bundle B has the transcript, but I must apologize in advance if we do have to check the transcript. We weren't able to recover all of it as the Court Smart CD that we got from the court didn't contain the whole case. But that's just a matter of housekeeping. It shouldn't detract from my submissions at all. And I don't
I mean,
think
that might be helpful enough because if there is any disputed portion that I'm invited to listen to via Court Smart audio, then if you can directly point me to a time and a date, then that may not be too onerous on the court.
right, I could certainly do that. I just wanted to flag it up at the beginning that it's not complete.
Okay, that's fine.
So my lady, I have, I'm cognizant of the time, so I'm sure, well, my lady, have you had a chance to review the amended skeleton?
I have it in front of me. I've glossed it.
Okay. So I'll quickly go through the facts and then I'll skip over a few sections to get to the argument.
Okay,
The facts of this offense, my lady, the appellant was charged with, on a date unknown, between the 1st day of April 2002 and the 30th day of April 2002 in Warwick Parish, sexually assaulting the complainant, contrary to section 323 of the Criminal Code. And that's what we're calling the allegation, of course, now for which he's been convicted. Whilst there was no formal agreement of the facts, it was not contested that between the 1st and the 30th of April 2002, the complainant was a 15-year-old student at the Bermuda Institute. At the time, the appellant had just recently turned 19 years of age. The complainant began speaking with the appellant sometime before April 2002, and after one or two conversations, made plans to meet him at his house. The complainant and her close female friend skipped school and caught the bus in order to go to the appellant's house. The complainant and Ms. Crockle were not wearing their school uniform at the time. Rather, each had on a jean skirt and blouse. At the time, the appellant was living with his parents in the upstairs apartment of number 4 Eastdale Lane, Warwick Parish.
okay, let me just pause you there.
Yes,
Should
ma'am.
we make some real effort not to unnecessarily call out names other than your own client's name?
Yes, ma'am. Yes, my lady. I can make the effort to do that. I don't
I
think
mean,
that
the information is in front of me, but is that not the standard approach in these kinds of cases?
Yes, my lady, I'm guided. I will refrain from using names.
Yes,
Once inside the residence, after approximately 15 minutes, the complainant was alone with the appellant in his bedroom. There was music playing loudly in the living room. where the friend was seated with approximately 2 or 3 other males. The music was playing so loudly that the people in the living room could not hear what was happening in the bedroom and vice versa. The appellant and the complainant began to engage in small talk whilst inside his bedroom. The small talk quickly led to kissing and fondling each other whilst the pair sat on his bed. The complainant agreed with the suggestion, and the appellant confirmed that he thought that the pair were going to have sex and that she was consenting. However, it is at this point, approximately in the factual matrix, that the parties' accounts vary. My lady, if you will, might you skip over the burden and standard of proof, elements and issues, and the law, which we can refer to as we get on with the argument.
Yes.
The argument, my lady, begins at paragraph 17, which is located at the bottom of page 5.
Okay. Yes, thank you.
Shall I continue, my lady?
Yes, thank you.
The crux of the appeal is that 1, the evidence adduced by the Crown and the appellant does not support the findings of the learned magistrate. 2, the learned magistrate did not properly consider a defense which arose on the evidence and was thereafter available to the appellant. And 3, the learned magistrate erred insofar as he did not properly direct himself on a matter of law. Beginning firstly with the evidence adduced and not supporting the findings. My lady, for clarity, please note that we have attempted to address this particular ground of appeal by making arguments under 3 subheadings, being that A, the learned magistrate erred generally in his findings about consent, B, the learned magistrate erred in his approach to credibility, and C, the learned magistrate erred in his approach to whether the appellant had an honest belief. Now, notwithstanding that the submissions under this particular ground are generally distinct, they do have a tendency to converge on similar points. So there may be a bit of overlap as I go through the argument.
Particularly A and C, I would expect that that would probably be best addressed collectively.
Yes, my
When I
lady.
say A and C, I'm using your own headings. The learned magistrate erred in his findings on consent, and he erred in his approach to honest belief. Those 2 would be convenient to address collectively. I'm not asking or directing you to do that. I'm just simply inquiring whether you would find it convenient to deal with those 2 together.
My lady, I'm just pausing, reflecting over what the argument actually says.
I don't want to take you off your steam, so if you prefer to do it another way, by all means, please.
I do, my lady, and
right,
and
that's
hopefully
fine,
the
go on.
reasons become apparent, because under A, I deal more so
You don't have
with,
to explain it to me. You can just deal with it the way that you.
yes, ma'am, I'm grateful. Thank you.
Okay.
Dealing firstly with the learned magistrate, generally, the learned magistrate's erroneous general findings as they relate to consent. With respect to the allegation, the conviction, that is, I should say, the appellant did not deny that he had sexual intercourse with the complainant. However, his evidence was that it was consensual. Accordingly, he relied on section 233, subsection 5 of the Criminal Code, insofar as there was sufficient evidence to establish a reasonable belief that that said belief constituted a defense, because in reviewing all of the evidence, there are reasonable grounds for that belief. The events in question occurred some 19.5 years ago. Notwithstanding that memories have faded over the passage of time, the evidence of all 3 salient witnesses was such as to provide the basic factual matrix as outlined in paragraphs 2 to 7 above. In their evidence in chief, the appellant and the friend both recalled the group socializing in the living room before the appellant and complainant retired to the appellant's bedroom. Under cross-examination, the complainant conceded that she, quote, met him once, but could not remember how. However, in any event, the pair met and began conversing via telephone with...
I'm sorry, I thought you were reading from your submissions. The quote you gave at paragraph 23 is different from what I see in front of me. I have she didn't know him well enough to like him, but she found him so attractive that she wanted to go and meet him. Were you
Yes, ma'am.
paraphrasing?
That's it. No, my lady, I was reading from paragraph 22.
Oh,
You're
I
at
see,
paragraph
I see.
23.
Oh, I see. I see. I apologize. Thank you.
That's fine, my lady. The complainant admitted, as you just said, under cross-examination that she didn't know him well enough to like him, but she found him so attractive that she wanted to go and meet him. Indeed, her attraction and desire to go and meet him was strong enough to compel her not only to skip school, but to encourage her friend to skip school with her so that she could continue her dalliance with the appellant in person. Initially, under cross-examination, she attempted, meaning the complainant attempted to deny it. But after the defense brought her attention to what was said in interview with the police, the complainant reluctantly accepted that she, quote, orchestrated the entire thing, as those were her words. And when pressed further about the orchestration, she conceded that, quote, when she orchestrated this rendezvous, she knew it could potentially lead to sex. And when pressed even further, my lady, you'll see I asked the question at trial. You knew, this was in cross-examination, you knew it could lead to a sexual situation like kissing and fondling and things that could lead to intercourse. Her answer was plainly yes. The complainant told the court she didn't know anything about the appellant, yet after a short while, quote unquote, the complainant retired to the appellant's bedroom with him. She admittedly was alone with the appellant in his bedroom despite not knowing anything about him. On her evidence, under cross-examination, there was approximately 5 minutes of small talk before the pair began kissing. And the evidence was that it was at her instigation. The following sequence of questions and answers was put to and answered by the complainant. Then after 5 minutes of small talk, you're making out with him on his bed. Yes, he's fondling you. Yes, he's rubbing your thighs. Eventually he starts fingering your vagina. Yes, he put his fingers in my vagina. You gave him easy access by wearing a skirt, didn't you? Sure. My lady, this evidence we submit humbly goes directly to the mindset of the complainant, and I'll touch upon it as I get on with the argument, but I wish to just flag it up right now because the learned magistrate referred to the evidence of the supporting witnesses, which went to the complainant's mindset, but he seemed to gloss over or skip over really this evidence, which also goes to the complainant's mindset, that she deliberately wore a skirt in order to give him easy access to her vagina.
Okay, pause for a moment.
Yes, ma'am.
Mr. Coelho, do we have any update as to what the position is with Court Smart?
Yes, I've checked it myself. It is recording.
Thank you. Yes, okay.
Shall I continue, my lady?
Yes, please, Ms. Wilson.
Thank you. Continuing with the questions, 55. This was someone who moments before you say you had never met face to face. Yes, you remember telling the police you had a button-up shirt on, correct? Yes, and you told the police he unbuttoned your shirt. Yes, no, sorry. You didn't tell him not to unbutton your shirt. No, you told the police that you allowed him to unbutton your shirt. Yes, to the point where your bra was showing. Yes. You were well developed back then too, right? Yes, I had boobs. So you allowed him to see your bra. Yes, you told police that you didn't recall what he was wearing, but I put to you that he had on jeans and a t-shirt. Okay, I don't recall. And 64, I'm sure you'll disagree just to be contrary, but you were sending sexual signals. And at trial, you'll see that I have this part crossed out because I didn't add that part in the question. She said yes.
I see.
65, yeah, so if you see anything
So
that's
any text that has a strike through.
that's something that I deliberately
For the
didn't.
fact that that was not said.
That was not said by me. That
Okay.
right.
Thank you.
Thank you. Yes, my lady. The signals you were sending were saying you wanted to be engaged sexually. Her answer was yes. So my lady, she agreed that the signals she was sending were sexual. So it follows that the appellant would have had an honest belief. Again, I haven't quite gotten there yet. So I'll come back to the submissions as they relate to the law in momentarily, but I just wanted to present some of the context for her ladyship so that you have a full picture. So continuing with paragraph 27, the following sequence of of questions and answers was also put to and answered by the complainant. In your chronology, he had maneuvered in between your legs prior to him grabbing your hands and holding your wrists. Yes. So you allowed him to put himself between your legs. Yes. You'll see 78 has a strike through. 79, if you didn't want him in between your legs, you could have told him no or stop. Don't do that. Yes. You allowed it. Yes. So again, my lady, the sequence of events, just for your context, the pair is on the appellant's bed. They're kissing, they're fondling, lots of heavy petting, rubbing, fingering. He maneuvers himself in between her legs. She says, which was in her evidence, which I haven't highlighted, she says she became stuck because her skirt was such that she couldn't move once he was in between her legs, and that he pinned her hands back and that she screamed. That's her evidence. He, of course, denied that allegation. He denied that she screamed. He denied that he ever pinned her hands back. One, because he didn't do it. And two, he then also said that he couldn't do it because he had nerve damage in his hands. And this was evidence that came out in his chief. The learned magistrate hasn't said why he accepts her evidence or why he rejects his evidence about that. Just that he did not honestly and reasonably believe, which we humbly submit, he's conflated two tests, and I'll get back to that in just a few moments. He's conflated the two tests, right? He's brought them together when they should be kept separate. But here again, my lady, that the point is that she allowed it. She allowed this behavior, and she admits to allowing it. And this has to go to her mental state of mind.
She allowed on the Crown's case. If I understand you correctly, there was a mutual and a consensual agreement for some level of sexual engagement. And there came a point where she withdrew that consent. Was she not entitled as a matter of law to withdraw her consent?
My lady, what we're saying, yes, to answer your question, she's entitled to withdraw consent. But
so the question then becomes really as to what the magistrate, whose evidence the magistrate accepted.
Right, exactly. But he hasn't said why he accepts the complainant's evidence and why he rejects the appellant's evidence. He has to. And I'm going to get to this when I start approaching the law in respect of honest belief and an approach to credibility. It's, yes, of course. I'm not saying that he's not entitled to prefer the evidence of the complainant as to the evidence of the appellant, but he has to say why.
Okay. So
right?
in where's his judgment? Can we just have that open at the same time? Do I have it typed?
I have his judgment. I didn't include it in the bundle because
That's right, it's in the record.
It's page 142 of the record, my lady.
142?
Yes.
Okay, thank you. Here we go. So you make complaint, I would think, in respect of page 146, where the magistrate notes his conclusions.
Yes.
My judgment, all four of the prosecution witnesses were credible when testifying. In particular, I found the complainant to be straightforward, frank, and clear in her evidence, notwithstanding that she still appeared during the hearing affected by what she says occurred more than 18 years ago. She was extensively cross-examined by counsel for the defendant, and throughout she maintained her version of what transpired and candidly conceded her own behavior and actions and thinking at the time. In my view, she was an honest witness. Indeed, I find that the complainant was a reckless, and I think that's,
Irresponsible.
yes, reckless and irresponsible 15-year-old girl at the time who, due to her infatuation with the defendant, had gone off on an exploration in pursuit of him, but got more than she bargained for. But just to come to your point where the magistrate does not state why he found the complainant to be credible, do you not accept that that's some insight into his reasoning?
It's some insight into his reasoning with respect to the complainant, but he hasn't given any insight into the reason with respect to the appellant. And I think
The following paragraph, doesn't he? The defendant, on the other hand, was not entirely an honest witness. His attitude towards the event when testifying, and at the time, was of a callous, unfeeling person who only wanted sex from the complainant. The attitude dealt with the evidence. Sorry.
Yes, I was going to say, and I'm going to come to all of these points, but right now I'll just flag it up since my lady brought it up.
Mhm.
The learned magistrate hasn't identified true reasons that go to credibility. The appellant being callous, unfeeling, and only wanting sex, those aren't reasons that go to credibility, my lady. He could be callous, he could be cold, unfeeling, he could be all of those
Still
things
credible.
and still, sorry,
And still credible.
and still be a credible witness. My lady, I'll continue before because I don't want to lose the flow of things. I trust me, I do get to.
But it helps
ma'am.
me, I have to
Yes,
say, if you can keep your flow at the same time while assisting me. It
Yes,
helps
of
me
course.
for you to just flag out the portions of the judgment which are subject to your complaints.
Yes,
So that
ma'am, of
I
course.
can cross-reference that.
Yes, ma'am, of
I
course.
mean, I have your submissions, I can read them. I mean, it may be helpful for you to read them to me, but it's also there for me to read afterwards.
Yes,
So
ma'am.
you can just, really take me through the evidence and the record. That's what's most helpful, because when we adjourn, I will have the exercise of looking at the evidence and wanting to see where these portions that you referred to,
Will they actually take place?
where the parts of the evidence that you say is relevant, that you
Yeah.
should have looked at differently and
Yes,
and
ma'am.
so forth. On the record, sorry, the record references.
Yes, ma'am. Will do.
Mhm.
So returning to the submissions, in its closing argument, the Crown suggested that the complainant, quote, urged it to be stopped when things started to progress more sexually. Yet clearly under cross-examination, the complainant accepted that as the appellant maneuvered himself in between her legs, if she didn't want him there, she could have told him so, but clearly she allowed it. My lady, and earlier in the cross-examination, the complainant had accepted that by that time, the appellant was in between her legs. He had been fondling her, rubbing her thighs, and figuring her vagina. She even said that she wore, as I mentioned earlier, she said that she wore a short skirt to give him easy access. Consider the following sequence of questions put to and answered by the complainant. So again, according to you, you allowed him to kiss you with tongue. You allowed him to fondle you. You allowed him to unbutton your shirt. You allowed him to see your bra. You allowed him to hike up your skirt. You allowed him to position himself in between your legs. You're telling us you didn't intend to have sex, but you can see how he may have thought something different. She says he can think what he wants. So again, just as it goes to mindset, this is something that that we submit humbly, that the learned magistrate should have considered.
Let me ask you this, Mr. Wilson.
ma'am.
If taking the Crohn's evidence at its highest, if the complainant were to be believed on every matter that she stated in evidence, would that not be sufficient as a underlying evidential basis for the conviction of sexual assault?
If the complainant was to be believed,
Yes. Her evidence, if believed, constitutes the offense of sexual assault.
well,
For
yes.
example, she says she screamed, she pushed, and so forth. You don't take any issue with your complaint, correct me if I have misunderstood you, is that the magistrate ought not to have believed the complainant, not even if you take everything that she says to be correct, it doesn't make for a section 323 sexual assault case.
Our position is now, as it was then, that she didn't do those things. She didn't scream. She didn't.
No, please try and understand the question I'm asking.
Yes, ma'am.
It may shortcut matters, and it also may help me to focus on what really is at the heart of your complaint on appeal. If the issue as to whether or not the complainant was lying or not lying was put aside for a moment, if you were to take every single thing the complainant said to be truthful, that constitutes an offense of sexual assault. Do you accept that?
Yes.
Okay.
Well, yeah. If
Okay.
we
So-
disregard, sorry.
So this idea of all these things that she did, leading up all these consensual sexual acts that she partook in, really doesn't take us anywhere in terms of how he should have treated the evidence, because all of her evidence, if you're looking at everything she said that there came a point in time where she pushed and screamed and kicked off, and that's her case.
Yes, but my lady, you can't lose sight of the fact that when he considers all of the evidence, he has to consider all of the evidence. He has to consider all of these questions that I asked and she answered very candidly to. He has to consider the parts of the evidence that would give the appellant an honest belief. So what I'm saying essentially is that, yes, okay, as your ladyship has put it, frankly, if we just said, right, if we believe everything that the complainant said, does it amount to sexual offense? Well, yeah, it does. But here's the point. When you're assessing the evidence, we humbly submit, when the learned magistrate was assessing the evidence, he had to look at all of the evidence and how the evidence congealed. And what we're saying is, with everything that she said, that she turned around and said, okay, right now I'm going to push you off and scream. And by the way, no one else heard a scream. And there was no other evidence to suggest that she pushed him off. How the learned magistrate then says, okay, right, I'm going to accept everything that she said, but I'm going to reject everything that
So
the
then,
defendant said.
again,
And if he does, fine,
let
but
me
but he
interrupt
hasn't.
you, not the other way around, please.
Sorry?
So once again, it would suggest that the relevance of all of these passages that you're referring me to, those are portions of the evidence that should make the magistrate disbelieve that she then physically resisted and physically fought against the sexual act continuing to the point that it did.
Yes, ma'am. I'm saying that it doesn't match. It doesn't follow.
Because she consented to kissing, she consented to fondling, she consented to undressing, and all of these other things that you're taking me through. Because of that evidence, the magistrate ought to have disbelieved that she suddenly withdrew her consent for everything past the point where she says that she kicked and screamed.
Yes.
You have to understand the context of why you're taking me through these passages.
Well, I think that accurately sums up the context.
So you say that the evidence is not believable because she was agreeable to the initial portions of the sexual engagement.
I'm not saying it as cut and dry as that. What I am saying is that the magistrate ought to have concerned himself throughout the whole assessment of the evidence with whether or not her evidence, if he chooses if he chooses to reject the appellant's evidence, he had to say why. And then if he did that, he had to then turn to the complainant's evidence, all of the evidence, and decide whether or not he accepts her evidence. And I can deal with that further on. But what I'm saying is he has to concern himself with whether or not it rises to reasonable doubt. Sorry, to be under reasonable doubt. Now, does all of the evidence put together take him there?
What is the evidence, or what are the reasons that you say she ought not to have been believed? That her evidence about the physical screaming and pushing, why do you say the magistrate ought not to believe that evidence? Because she consented to the earlier acts?
My lady, no, I don't think it's as simple as that. I don't think it's as simple as whether or not, or why she shouldn't have been believed.
Okay, so why should she not have been believed?
No, I don't know. I'm saying that I don't think that
I'm
that's,
asking you, why should the magistrate have disbelieved her evidence or been uncomfortable with her evidence and unable to satisfy himself at the requisite standard?
well, again, I'm saying that I don't think that that's the correct question to ask. It's not a
That is
matter
my
of,
question.
sorry?
That is my question.
It's your question, right? But what I'm saying is that according to how the authorities have said, the magistrate should have addressed the matter of credibility and honest belief. It's not merely a question of, well, what evidence has she said or not said that causes
No, I
him
haven't
not
confined it
believe
to
her.
evidence, just period. Why do you say it may be that you think her demeanor was improperly assessed or whatever the case may be? But I'm asking you, what is it that the magistrate overlooked which led him to wrongly assess her credibility?
I'm not sure if I
What is
can.
it that he, where did he err in wrongly assessing her credibility?
Well, in assessing her credibility, he would have had to have consideration for all of what was being said. And all of what was being said doesn't congeal, it doesn't gel, it doesn't flow together.
And are you back to now the portions where she was agreeable, the sexual?
I'm talking about all of the evidence, not just the complainant's evidence, but the appellant's evidence as well. For example, I'm talking about, and I can appreciate if my lady is unfamiliar with the rest of the evidence, but there were portions of evidence where the appellant said in either chief or cross, that he was familiar with the secretions of a woman's vagina. He had had sex multiple times. He was not the type of, he was experienced with knowing, what happens just before sex and the like. So it's not just about whether or not,
As in when a woman is aroused?
yes, when a woman is aroused,
Let's say that she was aroused during the time that she agreed to the sexual, let's call it in different stages, or first base, second base, third base. She was aroused on first and second base. Third base, she changed her mind.
yes. And
So so his evidence that he's familiar with the different stages of arousal, or however you want to phrase it, that should have put doubt as to her credibility. I don't want to be arguing with you. I want to make sure I understand you, Mr. Wilson. And so far, I'm not certain that I do. I'm not debating you, but I really, really don't want to overlook what your argument is.
well, let's continue then.
Okay.
So I'm continuing with paragraph 31.
31.
Yeah. Does my lady have it?
I do. It was clear.
It was clear that there was plenty of evidence which would cause the appellant to honestly believe that the complainant was consenting to the act of sex. Disappointingly, the learned magistrate made it an element that the belief not only be honest, but also reasonable, when that was not required of the appellant. The learned magistrate, in his ruling at page 5, paragraph 1, stating that, however, I also find that the defendant did not honestly and reasonably believe she was still consenting when she screamed, tried to push him off, and or urged him to stop. We will return to the error in relation to an honest belief in submissions below. However, we implore the court to note that it was not for the appellant to prove that it was an honest belief. Once raised, it was for the Crown to negative or disprove that he had an honest belief.
Did they not disprove it through her evidence that she screamed and tried to push him off?
Well, that's just part of the evidence. When they put it to him, he said that she didn't scream. She was moaning, she was panting, she was breathing as if she enjoyed it.
That's what he said.
Yes, that's what he
No,
said.
Yes, I didn't hear you. Yes, thank you.
Yeah, he said those things. He said that he did not pin her hands back. He did not, he couldn't have done that because of the nerve damage. So yeah, so it's all of the evidence that has to be considered. And by doing this, the Crown shifted the onus, the court shifted the onus onto the appellant. And just as an aside, we would humbly submit that it was not for the appellant to discredit what the complainant was saying. It was for the Crown to prove its case and to disprove the appellant's honest belief, because that's what we had established. We had established that he honestly believed she was consenting. The only evidence on which the learned magistrate could rely in relation to the complainant recanting her consent to have sex came from the complainant herself. But we respectfully submit that the learned magistrate erred in his conclusion that the complainant, quote, screamed, tried to push him off, and or urged him to stop. There was no evidence other than the testimony of the complainant of anyone screaming. Now, of course, I think I've already flagged this up, but when I make this submission, I'm not saying that the learned magistrate wasn't entitled to come to a conclusion solely based on the complainant and her evidence. What I'm saying when I make this submission is that his approach had to be a little bit different. He had to, one, reject the appellant's evidence and show why he doesn't. Then he has to turn to the complainant's evidence and show why he accepts it. When I say the complaint, the rest of the evidence in the case. When put to the appellant as to whether she screamed, he denied it, as I said. He said she was moaning, making noises commensurate with and indicative of her enjoying it. Defense counsel did fail, as noted by the learned magistrate, to put directly to the complainant that she was moaning throughout the ordeal rather than screaming or telling him to stop. But the line of questioning adopted by defense counsel suggested that the complainant didn't scream. Nobody else gave evidence that they heard a scream. Accordingly, we submit that the learned magistrate erred in reaching that conclusion insofar as the evidence of the other witnesses and the appellant doesn't support his finding. And again, we would reference the fact that he has to provide reasons for his finding. Next, paragraph 36, my lady, consider that the learned magistrate at page 4, paragraph 7, said that he, quote, accepted the complainant's evidence and found that she later resisted the defendant, tensed up, tried to push the defendant off her, telling him to stop, end quote. He said this despite her evidence in cross-examination that she was sending signals, quote, she was sending signals which indicated that she wanted to be engaged sexually. And despite her evidence also being that if she didn't want him to be in between her legs, she could have said no. That he concludes that she tried to push him off and or urged him to stop shows that he has clearly preferred the evidence of the complainant to that of the appellant, but he hasn't said why. The only explanation he gives is that paragraph 5 of page 5, that the defendant, on the other hand, was not an entirely honest witness. His attitude towards the event when testifying, and at times was of a callous, unfeeling person who only wanted sex from the complainant, and he had no care or concerns about her feelings. Accordingly, he has taken into account factors of morality, which he ought not to have considered, and it seems he has allowed his emotions to influence his decision. We'll return to this point in our submissions below, but with all due respect to the learned magistrate, that the appellant came across as callous, unfeeling, and appeared to have only wanted sex does not undermine the credibility of the appellant as an honest witness. The prosecution, in its cross-examination, did nothing to undermine the quality of evidence given by the appellant. So there was absolutely no basis for the learned magistrate to say that he was not an honest witness. There was never anything shown in cross-examination or otherwise that could lend itself to the possibility that the appellant wasn't being truthful. If anything, it was equally arguable that his demeanor showed the opposite, that he was entirely honest. If he felt guilty, he would not have been so matter-of-fact about the incident. And my lady, you did mention this earlier, and I'm not sure whether you meant that you would read the transcripts or you would look to Court Smart. I can do both. I can provide you with the dates and the times. And I raise
I would prefer, I always prefer to refer to the record, but if there is a dispute as to how the magistrate has noted the evidence, and you can refer me to your transcript.
Well, no, what I was going to say, and I'm saying this because having read my learned friend's response, and also having seen a few of your judgments, I know that you and other, your ladyship and other courts rarely like to go behind a magistrate because they would have had the chance to listen and see the appellant on the stand. But in this instance, if your ladyship is minded, you'll go and you hear the appellant and his answers. You hear that he wasn't callous, he wasn't cold, or he was simply answering the questions that were put to him. It wasn't. I'm not sure where the magistrate. I'm not sure why the magistrate concluded that he was callous and unfeeling and, and a cold witness. He may have only wanted sex, but he admitted that. He was a 19-year-old boy. He was only interested in sex. I mean, that's the context that this whole ordeal takes place. They were two teenagers going at it. 20 years later, anyway. Like I said, I'll return to that.
What was the age of the complainant?
She was 15 and she was just about to turn 16. I've also got that here in my skeleton. Where did I leave off? Right, I left off at 39, my lady. Mm-hmm. Accordingly, that the learned magistrate found the appellant was not entirely honest remains unsaid. It should be noted that the learned magistrate is duty bound to provide reasons for his decision. And if his reasons for deciding that the appellant was not entirely honest is only because he appeared as a callous, unfeeling person who only wanted sex from the complainant, then that is wholly insufficient. Moving on to paragraph B and the learned magistrate's approach to credibility, we say that he erred in that approach. Mm-hmm. The learned magistrate preferred the evidence of the complainant to that of the appellant, but there was no other evidence which supported the complainant's testimony. Accordingly, we submit that the learned magistrate's conclusion that the complainant's account was accurate and the appellant's account was inaccurate, with no other evidence, was erroneous and unsafe. The only evidence that is corroborative of the complainant's account was that the complainant came out of the appellant's room visibly upset and disheveled. However, that is insufficient to then conclude that the events that occurred inside
This
the room,
evidence was that the friend?
that was the friend's evidence, yes,
Okay.
went exactly as the complainant said they did. Therefore, it's respectfully submitted that the learned magistrate erred in his approach to assessing the credibility of the complainant and the appellant. Essentially, he shifted the onus to the appellant, requiring that he prove either that the complainant had consented to the acts or that he had an honest belief in her consent. Now, taking you to the case of Antoine William Bean and the Queen,
Mhm.
this was our Court of Appeal set out the correct approach in a case where the primary evidence was that of the complainant and the defendant. My lady, please forgive me. I don't know which tab in particular this case occurs in the bundle, but
It's tab 4.
thank you, my lady. I did want to, to me, this was a rather important case, and I just wanted to read more than just what's highlighted in the skeleton. So if I can, I'll take you to the first page of Antoine Bean. Antoine Bean, the appellant, was charged in an indictment containing 2 counts. The first count charged that the appellant had unlawful carnal knowledge of a girl under the age of 14 years. The second count charged that the appellant had unlawful carnal knowledge of the same girl when she was over the age of 14 and under the age of 16. It was alleged that the first offense was committed on a day unknown between the 1st day of July 2000 and the 19th day of August 2000. And the second offense was committed on the 12th of September 2000. The 2 offenses were therefore charged to have taken place within a short frame of a few weeks. By verdict of the jury, the appellant was found guilty by a majority of the offense charged in count 1, and by a majority he was found not guilty of the offense charged in count 2. Although it was not the subject of any ground of appeal, we mentioned that on the face of the record, these verdicts would appear to be unsatisfactory because they are inconsistent with each other, since the case depended solely on the evidence of the girl to support the allegations of carnal knowledge.
Yes.
The jury must have accepted her evidence concerning count 1, but rejected her evidence on count 2. The appellant appealed his conviction to this court on several grounds, but the submissions under ground 1 attracted most of our attention, since it appeared to us on reading the record of the summing up at pages 75 to 86 that certain flawed directions were given. Ground 1 complained that the trial judge misdirected the jury in several places in her summing up. Ms. Christopher identified in particular the following passages in the record of the summing up, which she characterized as misdirections. A, at page 80, however, a part of your function is to assess the witnesses and decide whom you believe. B, at page 83, now I will not review the evidence of Tyrone Smith. Am I allowed to say those names? I don't. None of them were present at the 2 incidents. Remember, this is a case where you have to believe the defendant or the complainant's evidence about the incidents. At page 83. So you will have to look at the evidence that he did give and see if you find him a believable witness. It is simply a matter of who you believe. D, at page 85, do you accept that the defendant could not have the use of his roommate's car? It all comes down to whom you believe. E, at page 85, well, ladies and gentlemen, you will have to decide for yourselves whether these explanations make you sure that the defendant did not commit the offenses charged, or whether or not they are sufficient to cast doubt on the complainant's evidence. F, at page 86, ladies and gentlemen of the jury, that concludes my review of the evidence. You will see that it is just a matter of whom you believe. At the beginning of her summing up, the judge gave the jury a correct direction on the burden of proof when she stated at page 76 to 77,
Mr.
I will,
Can I just stop you there?
yes, ma'am.
Is there any contention between you and the prosecutor that that is the wrong approach and that the Crown has to prove its case? It's not a question as to whether or not you believe the defendant or you believe the complainant. It's a question as to whether you're satisfied beyond all reasonable doubt of the Crown's case. If the purpose for your reliance on this case is to make good that legal principle, can I just first inquire whether there's any contention about that?
Is that a question for me, my lady, or?
It's a question for Ms. King Dean.
Sorry. Sorry, my lady, just trying to unmute. No, my lady, I think that you're correct, that it's a question of us proving our case beyond a reasonable doubt. It doesn't come down to whether or not the magistrate believes one person over the other.
And now back to you, Mr. Wilson. Do you say that that is the approach that Magistrate Tukumbo followed, that he invited him in directing himself? He made it a competition between the credibility and believability of the complainant versus the appellant?
Yes, my lady, that's how it appears to me.
Okay. And you rely on the passages that you've taken me to for that submission to be made good, where the magistrate in his conclusory remarks talks about not having found the defendant to be honest when he assesses the credibility of the defendant and assesses the credibility of the appellant. I mean, why do you say I don't want to put words in your mouth, but I do want to be helpful. Why do you say that he adopted this very flawed approach, which I think is now well-established legal principle?
The reason why I would humbly submit that he adopted that approach as to whom he believes is because, quite frankly, he didn't say why he rejected the appellant's evidence in his judgment. It seems to me, just in reading his judgment, that he simply chose to believe her as opposed to him. And that's because, I think I do elaborate it on, as I get on into these submissions. The appellant didn't give much evidence, if I could just put it that way. And he wasn't extensively cross-examined. I'm not casting any, I'm not saying that Ms. King Dean didn't do her job, but what I mean by that is he certainly wasn't questioned for as lengthy a period of time as I questioned the complainant. So there wasn't a whole lot for the magistrate to decide upon.
I mean, do you say that the magistrate felt compelled to accept one case or the other?
I say that, yes. To me, it seemed that he chose the evidence of the complainant as opposed to the evidence of the appellant, but he hasn't said why. He hasn't. I keep coming back to that point because it's just not in his reasons anywhere.
Okay, let me put it differently. Do you say that it was somehow lost on the magistrate that he could have rejected the evidence of the complainant and he could have rejected the evidence of the appellant, and he could have formed an opinion that they were both being dishonest, and that would lead him into forcibly having to acquit the appellant? Did you say that he would not have been alive to that?
Well, I don't know what he was alive to because it's not in his reasons. I don't want to say that it was lost on the learned magistrate that he could have rejected both, but he hasn't said what he's done. He hasn't said anything. And I mean, I guess that I'm not.
Okay, let me ask you this. Do you say that he did not satisfy himself, that he did not feel satisfied beyond reasonable doubt that the Crohn's case was reliable and truthful and
Well,
proven?
he says that he satisfied himself. He says that he felt sure, but he hasn't said why he feels sure. He hasn't done what he was supposed to do. I mean, the appellant is entitled to know why his case is not preferred to the case that the complainant brings. He has that right, I would imagine. And the court hasn't done that.
Okay.
And just touching on what you just said, if we could skip down a few paragraphs, just because I want really to, to say
Let me
this.
not stop you from it. If you still want to go back to this case, that's fine. I just wanted some clarification whether or
I
not.
did. So I'll go to what looks like the middle of page 3.
Yeah.
And I'll just finish up with respect to this case. Starts off, however, as she progressed through the summary of the evidence, she proceeded to give the directions complained of by Ms. Christopher as derogating from the effect of the general directions on the burden of proof. This seems to have come about because she lost sight of the fact that the appellant did not have to prove anything. He did not have to make the jury sure that he did not commit these offenses. The directions should have been that if his explanations were accepted by them, and if his explanation satisfied them that he did not commit these offenses, or if the explanation created doubt, they should acquit. But, like you said, if his explanations were rejected by them, then they could only convict if they were satisfied and felt sure that the girl had told the truth concerning the sexual connection. Moreover, the judge should have directed the jury that they may reject both the girls and the appellant's stories, and that if they do so, they had to acquit. So that's exactly what I'm saying here, my lady. I would never suggest, well, I'm not saying that it's lost on him. What I am saying is that he didn't make it apparent what he was doing, and he has a duty to do that. And because he hasn't done that, the submission is that he didn't do that. The submission is there is room for the argument that he didn't carry out this part of the approach as it comes to the evidence. Returning to my submissions, my lady, paragraph 43. Our Court of Appeal adopted the words of the English Court of Appeal in Michael Edward Byrne, wherein the defendant had raised the defense of duress. We submit that these words are equally applicable where the defense is one of honest belief. The Chief Justice in Byrne wrote, "There is, however, another ground to which the court would like to draw attention. It concerns the burden of proof. Duress, like self-defense and like drunkenness, is something which must, in the first instance, be raised by the defense. But at the end of the day, it is always for the prosecution to prove their case, which involves negativing the defense, which had been set up. In other words, throughout, it is being left to the jury as a matter of whether they believe Byrne and not on the basis that if they think what Byrne says may be true, they should acquit. On that ground, the court has come to the conclusion that the verdict should not be allowed to stand. In this case, the learned magistrate ought to have instructed himself, and it should have been clear from reading his judgment that he kept in mind throughout that he had to be satisfied beyond a reasonable doubt of the following. One, that the defendant touched the complainant for a sexual purpose. Two, that the complainant did not in fact consent to the touching. And three, that the defendant did not honestly believe the complainant was consenting to the touching. There was no issue that there was touching for a sexual purpose. That was admitted by both parties. The prosecution, therefore, had the burden of disproving or negativing the defense raised. And at no time did the burden of proof ever shift to the appellant. The learned magistrate's reasons for judgment with respect demonstrate that he engaged in the exercise of choosing whether he preferred and believed the evidence of the complainant or the appellant. After setting out the highlights of the complainant's evidence and the appellant's evidence, the learned magistrate wrote, in my judgment, all four of the prosecution witnesses, as my lady had referred me to earlier. That's that paragraph that you referred me to earlier. Mm-hmm. So 47, thereafter, the learned magistrate criticizes the defense counsel for not putting certain questions to the complainant, yet he did not in any way address the failure of the Crown to show that the appellant was not an honest witness, or that he did not have an honest belief. And that's what we're saying. That's the Crown was supposed to negative that defense. We set it up like, hey, listen, look what she was doing. She was doing this, that, and the other. He was an experienced teenager who had lots of sex. He knew when a woman was aroused. She was clearly aroused. He had an honest belief that they were going to have sex consensually. It was never negatived by the Crown. And so how the learned magistrate came to his conclusion, we say, is erroneous. The Crown did nothing to undermine the quality of evidence given by the appellant. Accordingly, there was absolutely no basis for the learned magistrate to say that he was not an honest witness. We respectfully submit that this honorable appellate court cannot be.
Mr. Wilson,
yes, ma'am.
You accept that the Crown did not have to, or the magistrate in assessing the Crown's case did not have to point to any corroborating evidence of the complainant's evidence. The Crown's case could be proven on the complainant's evidence alone if the complainant's evidence was believed.
Yes, I've said that a few times.
Mm-hmm.
I'm not saying that the magistrate could not have concluded purely based on what the complainant said, right? But what I am saying, I'm just drawing to the court, to your attention, your ladyship's attention, that there was no corroboration evidence in several regards, and that the learned magistrate, in his approach to how he came to accept the evidence of the complainant, I'm saying that that was wrong. I'm not saying that he couldn't do it. I'm just saying that he approached how he accepted it incorrectly. We respectfully submit that this honorable appellate court cannot be satisfied on the reasons given.
Let me ask you this, just pause for a minute. I am going to ask you questions. It's very routine and common.
Yes, ma'am, of course.
Unfold. It will assist me and hopefully your client to the extent that I fully understand your arguments and the points that trouble me.
Yes, ma'am.
Your complaint about the magistrate's assessment of credibility has been very much focused on how he treated the appellant's evidence. How do you complain about the way that he assessed the credibility of the complainant's evidence?
Well, I don't know that I made submissions in that regard. His assessment of the complainant's evidence, I haven't specifically said it, but in the in the discussion
What's
that
your case?
you and I had.
Do you make complaint about his assessment? Because I understood you to have made that complaint, which is what led me to reading out the passage from the magistrate's judgment about how he treated her evidence. Found her-
Right, yeah, so I was saying that in the discussion that you and I had earlier, I was saying that he should have looked at the whole of the evidence, which is not just, so for example, the learned magistrate talks about how the supporting witnesses give evidence as to the complainant's state of mind. So clearly he's directing himself in that regard. He doesn't then look at the complainant's state of mind, or rather he doesn't show that he's looking at the complainant's state of mind with respect to her evidence of wearing the skirt so that her vagina was easily accessible, and other things that I've highlighted earlier in my submissions. So it's from that angle that I'm saying, it's from that angle that I'm making the complaint. And what I meant by I didn't specifically make the complaint was I didn't put it in writing in my submissions, but you and I had that discussion earlier when I was making the submissions, if that makes sense. So I didn't put it in my skeleton argument, but you and I had that discussion. And I don't know if I'm being clear.
Well, I mean, my question to you is whether or not you found complaint in the magistrate's examination of the Crown's evidence. Yes, there comes a point in time after the defense case has been called that the magistrate will look at all of the evidence in the round, but let's just take it one case at a time and start with the Crown's case. At the close of the Crown's case, the magistrate obviously would have assessed and directed his mind to questions of sufficiency and so forth. Was there a no case submission made in this?
No.
In this case, no. Okay. So there was an acceptance that there was sufficient evidence for the defense to be called upon. Are you following me so far?
Yes, I think so.
So my question to you is the magistrate, in assessing his view of the credibility of the Crown's case before the defense was called, you make no complaint about.
The magistrate, could you please repeat that?
The magistrate, you make no complaint about the magistrate's assessment of the Crown's case taken independently of the defense case. There was sufficient evidence for the defense case to be called because the magistrate assessed the sufficiency of the evidence, would have naturally directed himself. You didn't make an application for a no case submission.
Well, okay. It is when you, my lady, when you refer to the Crown's case, are you also including the cross-examination of the complainant? Or are you merely referring to the evidence of the evidence in chief of the complainant?
Well, you'd have to be careful because in that cross-examination, you would no doubt be putting things that would have to be substantiated by the defense thereafter.
Yes, I was putting things that would have to be,
But in terms of just making out, because let me see if I can put my question differently. You make no complaint that the Crohn's case taken in isolation satisfies, on the face of it, on a prima facie standard, the offense with which your client was charged.
right. So that's similar to the question that you asked earlier.
It is, I'm just trying to ask the same question, I can tell you.
That if we take everything that the complainant has said and we simply just believe everything that she said, is the offense made out? And the answer is yes. If we look at just what the complainant says, then the answer is yes. But
Hold on one moment. But at a no case submission, if there were, for example, if the Crohn's case was riddled with inconsistencies, if the Crohn's case was tenuous and weak on the basis of a multitude of inconsistencies, then you would have made a no case submission, no doubt.
yeah, but I didn't think that it was tenuous to the point where a no case would be successful, right?
So your complaint, correct me if I'm wrong, is that you say that the evidence from your client undermined the Crohn's case, which was on its own enough to at least pass a sufficiency threshold.
No. I'm saying that if we merely look at the complainant and what she said, right, in chief, right? So she said that she skipped school, she was making out, she was on the bed, and then, it got to a point where she no longer wanted to continue, and she started resisting and then screamed, etc. Right? That's her case. But then in cross-examination, she made certain admissions. She admitted certain things. One of them being that she wore a skirt to give the appellant easy access. One of them being that she agreed that she was sending sexual signals, and one of the sexual signals being that she wanted to be engaged sexually. So what I'm saying is, those are inconsistent with her statement. But it to me, and I mean, maybe I should have, maybe a better lawyer would have done so. Maybe they would have made a new case. But to me, it didn't seem that it would pass the test for a no case. So I didn't make that. I didn't make that application. But the magistrate, when he goes to consider all of the evidence, he has to take into account the fact that in cross-examination, she said, hey, I orchestrated this thing. I knew he was older. I was infatuated. I did want to go see him. I wore a skirt purposefully because I wanted to give him easy access. I did X, Y, Z. I did this, and this. And so then to go from doing all those things to then saying, okay, right, yeah, he had sex with me without my consent. And oh, by the way, it's 20 years later, and I'm making this complaint against him. I'm saying
If your client had not given evidence, would you find complaint in the Crohn's case being successful if your client had exercised his right to silence?
I would have found complaint, but we couldn't afford to have done that.
No, I'm not challenging you.
No. What I mean is, and because this takes us also, to the age point, right? And that's what I meant by that, right? But let's put the age point aside. Let's say that she wasn't under the age of 16. Let's say that she was 16, and so the Crown couldn't rely on that. Mm-hmm. If we had the exact same case, and my client exercised his right not to give evidence, I still would have had similar submissions to you now. I just wouldn't have the support of him saying in evidence, him having put to him, hey, no, because he said flatly, he said, I did not do this. He said, I did not restrain her hands. There was no scream. And what I'm saying to you, my lady, is that is also evidence that has to be considered. And it's not just a matter of whether or not the magistrate chooses to believe one versus the other. He has to, if he does, then he has to say why he does. He can't just do that. He can't just say, right, well, willy-nilly, I believe this person as opposed to that one. Why? What?
All right, Mr. Wilson, it is just 2 minutes shy of 4:45.
Yes, ma'am.
I do not, I think it would be right for me to hold any member of staff here hostage.
Yeah.
So we will have to clearly continue because I haven't heard from everyone yet. You don't seem to be winding down within the next 2 to 3 minutes.
No, ma'am.
So why don't we spend the next 5 minutes just agreeing a date to come back, okay?
I'm grateful, my lady. Thank you.
My lady,
Yes, thank you, Mr. Cueto.
could I see you in the breakout room, please?
Yes, thank you. Just give us a moment, please. I'm gonna just
Yes,
break
my
up.
lady.
Thank you. Okay, I'm told by Mr. Coelho, to whom I'm very grateful, that he is willing to stay on and we can continue if that is not difficult to counsel. Any issues arise with either of you?
No issues for me, my lady. I'm looking at the time and I am grateful for Mr. Coelho. I at the rate we're going with, and this, I mean no offense to the court, just to you, my lady, but you and I are engaging in discussion quite often, and I'm trying to satisfy her ladyship of my argument. We could be here easily for the next hour and a half. So if
Hour
Mr.
and a half on your submissions?
My lady, yes. I'm about halfway through. I'm on page 13 of 24. What I can say is the remainder of the submissions are much more brief. They're not.
I don't ask questions. Is that some sort of an invitation for me to stop asking you questions?
I wouldn't say that. I would never say that. You ask as many questions as you need to for you to understand.
All right.
What I'm saying is that the remainder I have.
I just lost touch of your submissions. 1 second.
I just meant to confer that the remaining submissions, I think, are much more simple.
Yeah, it's not a question of simplicity as it is so much time. I'm not going to sit here for another hour and a half and then the Crown, even if traveling at a very high pace of speed, I should at least allocate a half an hour estimate to. I can promise you I will not, I have no intentions of sitting that long, whether either of you are agreeable. I have my own limits. And
Can we come
so
back tomorrow?
let's not be, yes, let's not be overly, I would have been prepared to go to 5:30, but that's really it. And I would have been motivated to go to 5:30 if we were going to be finished by then. That would presume that you would have been finished within the next 10 minutes,
Oh,
10,
no,
15 minutes. And if you're not going to do that, then let's not waste
no.
time with that. Might have even persuaded me to go to 5:45, but that's really pushing it. And again, that would be with some confidence that, we're winding up and we're finishing.
I would try, but I don't think that I would be doing my client justice.
Nope, and I don't want anyone to misconstrue my efforts as rushing you into it. So let's just get a continuation date.
Yes, ma'am.
All right.
Milady, how soon would you think we'd be able to get this back on?
I am looking at the first week of November.
That would be fantastic, my lady. I'm actually on leave the week of the 25th of October, so I'd wanted to avoid that week.
We can come Monday morning, Monday, the 1st of, I know that that's a arraignment session, so I want you to fix your mind to that, but I would.
That's fine. I can have someone hold if I have any matters, my lady.
Thank you. And of course, I have my own set of matters in the afternoon, but I think I have a very short list. I think I only have one matter on my list, so we can actually probably put that done for 3 o'clock, or let's see. In fact, I wouldn't even say 3 o'clock, because the only matter that's on my list right now is a mention. I've given all the directions. Council just were keen to just, I think, have it confirmed that 1 or 2 directions that I did give would be, have been followed. That's it.
Okay.
So I really could list this for 2:30 with the view that we might start 10 minutes after the 2:30.
That would be
start time.
convenient for the Crown, my lady.
Mr. Wilson?
Yes, ma'am. Monday, the 1st of November
At 2:30.
at 2:30. Yes, ma'am. That's
Okay,
fine.
let's do that. And that will, in all likelihood, be the same Zoom session as set up by Ms. Dyer for the other mention, because
Okay.
that's going to be a court. And I think that will be live streamed as well. So it makes sense to just deal with that in the same Zoom session. You should get the same details.
Grateful, my lady.
Okay, so adjourn to 1st November 2021 at 2:30 p.m. by Zoom.
Yes, ma'am.
Thank you.
All right.
And what's the position in respect of, has sentence been stayed in the magistrate's court, or what's the,
Yes, my lady, it has been stayed.
pending this appeal?
Yes,
This appeal's been kicking around for how long? Is this one of those things that,
It was affected by COVID.
it's number 15 of 2021, so that's not too. All right, so the notice of appeal was dated the 10th of March, 2021 this year. All right, I've seen more egregious delays. So we can, I think that's fine. That doesn't give me any particular concern. I think we can come back on the date I just fixed. All right, and the appellant is on bail pending appeal.
he is, my lady.
Okay, so any reason why bail should not be extended?
None, my lady. No objections.
Bail extended.
I'm grateful. Thank you, my lady.
Okay, thank you. All right, let's adjourn.
Thank you, my lady. Good
Thank
evening.
you. Mr. Quayle, can I get back into the breakout room with you, please?
Yes, good
Thank
evening,
you.
everyone.
Good evening, Mr. Coelho.
Thank you.
Quello.